and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at davestirepros.com. Tire Pros love the drive.
Please be seated. Is there anything we need to do before we bring the jury?
I just need to make sure that Lieutenant Folly is available.
He's right outside.
He's right outside.
Oh, is there? You want to bring him in?
Sure, thank you.
Thank you. Okay, please stand for the jury.
Good afternoon. Can you please state your name for the record?
Donald DJ Folly.
Do you go by DJ?
I do.
Where do you work?
Okaloosa County Sheriff's Office.
How long have you worked for the Okaloosa County Sheriff's Office?
Just made 24 years.
And what is your rank at the Okaloosa County Sheriff's Office?
Lieutenant.
And back on July 15th of 2021, were you a lieutenant?
I was not.
What was your rank then?
Sergeant.
So if anyone refers to Sergeant Folly, they're talking about you.
Back then, yes. And sometimes now. I forget.
Now, back on July 15th of 2021, were you wearing a body camera that day?
I was not.
Can you tell us why you weren't wearing a body camera?
I had just informally been told that I was taking this position at the courthouse as a lieutenant, so I had made arrangements to come talk to the current lieutenant here. So I put my body-worn camera on the charger and came to the courthouse to talk to the lieutenant.
Now, after you came to talk to the lieutenant, did you have the occasion to have contact with the defendant, Wendall Joseph Wright?
I did.
Can you identify the defendant?
I can.
Can you pick him out by a piece of clothing that he's wearing?
He's wearing a pinkish shirt with a gray tie.
Let the record reflect that Lieutenant Folly has identified the defendant, Wendall Joseph Wright.
The record will so reflect.
Now, let's get into the details of July 15th of 2021. You said you weren't wearing a body camera. So how did you become involved in this incident with Mr. Wright?
I heard it over the radio communications dispatch.
Was this in Okaloosa County?
It was, yes, ma'am.
So what did you do after you heard the radio dispatch?
I began managing the patrol deputies that I was in charge of within the county, within the South District, to get them arranged to possibly intercept the suspect.
So you were the supervisor in charge?
I was, yes, ma'am.
And did you become involved in the pursuit of Mr. Wright?
I did.
Can you tell us how that happened?
I had set up units around the airport and around south of General Bond, and as I was making my way through Northfield Extension toward 85, I heard radio traffic that Deputy David Nash was behind the vehicle on Sunset. Had identified the vehicle.
Okay, and what happened after that?
I was the closest unit. He went ahead and initiated a traffic stop. Mr. Wright did not stop, and the pursuit began, and I became the second vehicle in the pursuit.
Were you in an agency vehicle?
I was.
And did it have sheriff's office insignia on it?
It did.
And were your lights and siren activated?
That's correct, they were, yes.
Can you tell us more about your role in the pursuit of Mr. Wright?
I became, like I said, the number 2 vehicle. He did a U-turn. I was calling the chase. He did a U-turn and started heading north on 85. Once he got up to about 123, we entered 123, and as soon as we got north on 123, he ended up doing a U-turn. When he did, I became the first car behind him.
Can you tell us about your pursuit of Mr. Wright at that point?
Yes, ma'am. We traveled south on 123 and then entered 85, and then we traveled south on 85 until he did a U-turn and was traveling north again on 85. And then he crossed over into the southbound lane. He was traveling northbound in the southbound lane, at which time I terminated the pursuit.
Why would you terminate the pursuit when he's driving northbound and the southbound?
The ends didn't justify the means. It was a stolen vehicle, I believe, and maybe some other charges, but he was endangering people in the public, and I thought that if I terminated the pursuit, then he might stop driving as recklessly as he was.
Did you ever have an opportunity to check your speed during the pursuit?
I did. I believe I called it out on the radio several times.
And what was that speed, if you recall?
It was varying. I couldn't tell you. I'd have to watch the video. I apologize. It was varying from 50 to 80, I think.
So you did get up to 80 miles an hour?
I believe so.
What happened to make you re-engage Mr. Wright after you terminated the pursuit?
We all peeled off of the chase. We stopped pursuing, and he basically did a U-turn. He was traveling north on 85 just before 123, and he did a U-turn and began heading south in the southbound lane. We observed him because we couldn't turn off, so he was traveling south, and then he crossed over traffic without being pursued southbound in the northbound lane. So he was now running toward head-on traffic again. So at that point in time, I thought that we needed to end the chase because he was risking too many lives.
And did you observe Mr. Wright doing anything in his vehicle towards law enforcement?
I did.
What did you observe?
He was flipping us the bird. He was yelling at us every time we got a chance to see him inside the vehicle. He made it very known to us that he wasn't happy with us chasing him. He was, like I said, flipped us the bird, yelled at us, pumped his fist at us a couple times, stuff like that.
Did you ever have an opportunity to check your speed during the pursuit? I did. What did you observe?
He was yelling at us every time we got a chance to see him inside the vehicle. He made it very known to us that he wasn't happy with us chasing him. He was, like I said, flipped us the bird, yelled at us, pumped his fist at us a couple times, stuff like that.
So this may seem like an obvious question, but is driving northbound in a southbound lane legal? Is driving southbound in a northbound lane legal?
Okay.
I'm not going to ask that. Hold on a second. Was there a time before the final stop of Mr. Wright that you stopped your vehicle?
I did.
Why did you stop your vehicle?
He was kind of going in between all the vehicles that were heading northbound, and at one point in time he slowed down, almost like he was going to bail from the car. When he did, I went ahead and stopped in the median. I was probably roughly about 4 o'clock, just slightly off the right rear quarter panel of the vehicle. He was in the other lane, I was in the median, and I thought he was going to jump out of the car and run, so we stopped.
And what happened after you stopped?
I looked up, I was actually trying to exit my vehicle, and as I looked up and he was accelerating toward me. So I got back in the vehicle as best I could, steered away from him, and he did strike my patrol car.
So you were able to take an evasive action?
I was.
But at the time, you believed he was coming toward you?
Right toward my door, yes.
Were you placed in fear?
Absolutely. I wouldn't have turned away if I wasn't.
And you said you were struck?
I was.
And when you were struck, were you jostled around and moved in your car?
Just slightly, just enough not enough to throw me on the other side of the car, but I did feel the impact.
You weren't injured?
No.
But did you believe you could be injured?
If I had stayed where I was, yes.
Now, you mentioned earlier that because he was going, I believe, southbound in a northbound lane, that you believed you needed to stop him. How did you end up stopping Mr. Wright?
I sent units to 189 and 85 intersection to stop traffic so that we could reduce the cars that he was coming head on with. Hopefully that would, change his direction or whatever the case may be. And then finally, like I said, he was still going toward cars and like he was going to hit him head on. So as he pulled up into the median, like he was going to shoot across traffic or do whatever, I just went ahead and decided I was just going to take the vehicle out, make sure that it couldn't run anymore, if possible.
How did you do that?
I struck the vehicle in the back right quarter panel and spun it around.
Now, is there a particular name for that technique or maneuver?
It's kind of a modified pit maneuver. It's not really a pit, but with the environment I had to work with, that's the best thing I could do.
Are you specially trained in a pit maneuver?
I had received training, quite a bit of training in the past when I was associated with a SWAT team several years ago.
So do you have special training in trying to stop vehicles that are a danger in traffic?
Yes, ma'am.
Can you explain to us what a pit maneuver is?
That's basically when you're trying to get a vehicle stopped and the suspect vehicle's in front, the police vehicle's on the usually right rear quarter panel, usually about 35 miles an hour, and you just ease up to the car and you just kind of push the car, just accelerate, and basically all you're doing is just turning the car and it just spins out in front of you. That's basically what happens.
Is that to stop the car?
It is.
And were you able to stop the car?
I was.
And what did you do after you stopped the car?
He actually started to accelerate. It spun him around for a minute. Both of us came to a complete stop, and then he started to accelerate again, at which time I went ahead and he was moving toward other vehicles, like he was going to ram other vehicles again. So I went ahead and hit him on the left door, roughly door panel, and drove him in between two vehicles and into the wood line.
And what was your reason for doing that?
To avoid any more injuries or potential injuries.
What was your involvement after you brought Mr. Wright to a stop?
I exited my vehicle, and the other deputies had already surrounded him. He was kind of pushed up against the wood line, leveraged by my vehicle as well. So I exited. They were giving commands. He wouldn't exit. He was refusing, so we ended up breaking the passenger door or passenger window, and then I reached in and pulled him out.
Did you remain the supervisor on the scene?
I did until Captain Lenny Holloway arrived.
And this may seem like a silly question, but was the vehicle you were pursuing, was that an automobile that can be driven on the roadway?
Yes, ma'am.
And this may also seem like a silly question, but is methamphetamine a controlled substance that deputy sheriffs make arrests for?
It is.
And finally, was your vehicle damaged beyond repair?
It was total.
If I may have one moment.
Yes, ma'am.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Were you part of the officers surrounding Mr. Wright after he was stopped?
Not initially. They got there before I did. If that answers, I hope I'm answering your question. They were surrounding the car, and then I got out and involved them.
Did you issue any orders to Mr. Wright?
I told him to get out of the car, exit the vehicle.
Did it appear to you that he had the ability to exit the vehicle?
Absolutely.
Did he make any actions or moves to exit the vehicle?
No, not at all.
I'll tender the witness at this time.
Mr. McKinney. Good afternoon, Lieutenant.
Afternoon.
Back on July 15, 2021, what type of vehicle were you driving?
I believe it was a Ford Taurus,
Do you remember what the unit number was?
1969.
Do you remember when that speed had been calibrated with that speedometer on that vehicle?
I don't believe I ever did. No.
Is it you that we hear on video calling the speed on the radio traffic?
Yes, sir. Or some of it, yes.
And that would have been based on you looking at the speedometer and calling on radio?
Yes, sir.
The decision that was made to terminate the pursuit, was that your decision
To terminate the pursuit, yes, sir.
initially?
Yes, sir.
At which point in time, your testimony is that the vehicle made a U-turn and then traveled south
Correct.
in northbound lane?
It traveled south in the southbound lane, and then, without any prompting, crossed over traffic through the median again into the northbound lane heading south.
From that moment in time, is that when we see your vehicle continue to pursue Mr. Wright?
Yes, sir.
Did you re-engage lights and sirens?
I did.
And the discussion that was just had about moving into the median, you stated that we needed to end the pursuit when you re-engaged. Is that when you made the decision that we need to end this pursuit?
Roughly, yes. When I saw his actions, yeah, I was formulating a decision.
When Mr. Wright's vehicle is observed going around with the traffic in the northbound lane, when there is a good amount of traffic on the road,
Okay.
is that when your vehicle, you intentionally go into the median towards Mr. Wright's vehicle?
Trying to understand, was it when he hit me or after that?
First time.
The first time? No, I was not trying to ram him at that point.
At that point in time, you were trying to close the distance with Mr. Wright. Why did you drive across the median, is the better question?
I got in the median to exit my vehicle to intercept him if he got out of his car in the other lane of traffic.
Was Mr. Wright still trying to flee from the police at that point in time?
At that point, he had stopped, I think, because of congested traffic, but he briefly stopped. Like I said, it looked like he was going to get out of the car, is what I thought. So he came to a stop at that. I hope I'm answering your question.
My question is better asked in, is he trying to get away from you, or is he trying to do something to you?
He was trying to get away, came to a stop, and then turned into me and accelerated into me and hit me.
Would the video be the best evidence of what happened?
Probably.
When contact was made the first time, was the contact made with the front left of your vehicle with Mr. Wright's right side of that vehicle?
I would have to check my notes or watch the video, but I believe it was the front left quarter panel of my vehicle, I think.
In looking at that still photograph, can you describe where the contact was made with your patrol vehicle?
Yes, sir. Do you want me to hold it up?
If you could just explain it to the jury without holding it up.
Yes, absolutely. It looks like his front right quarter panel is meeting with my left front quarter panel.
Are you both in the median at that point?
We are. He is, looks like he may have, based on your picture, it looks like he may have one or either the front left and the front rear left, or one of them, one of the tires in the roadway. And I'm just guessing. It's hard to see it.
And at that point in time, were any of your car doors open?
No, sir. Not in this picture, no.
May I approach it? Yes, sir. So I guess after that discussion, do you believe that Mr. Wright was intentionally trying to have contact with you, or was he trying to get away from you and continue the pursuit?
I think he was trying to hit me to get me out of his way so that he could flee.
May I have a moment, Judge? Yes, sir. Any further questions?
Sandler? Please read around here.
Now, Lieutenant Folly, even though you were leaving the courthouse that day, were you engaged in your lawful duty as a deputy sheriff when
Yes,
you
ma'am.
were involved in the chase? And you stated earlier you thought he was going to run. Were you getting ready to get out of your car
I was.
when you were in the median?
Yes, ma'am.
And the location where you were stopped in the median, is that in Okaloosa County?
Yes, ma'am.
And so when Mr. Wright hit you, is that in Okaloosa County?
Yes, ma'am.
All right, that's all I have. Thank you.
May Lieutenant Folly be released?
Yes, sir.
Yes, sir.
Thank you, sir. Ms. Sandler, your next witness.
State restroom.
Counsel, if you'll approach.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review.
Face to face, to follow the deputy out. We'll see you in a little bit. Stand for the group. Please be seated. Yes, sir. Mr. McKinney? Yes, sir.
Make sure we're on the right mic. Judge of the defense, on behalf of Mr. Wright, would move for judgment of acquittals on all of the counts. Specifically, if we look at count 2, the driving license suspended, count, the third element is that the state must provide evidence that at the time when the Wright reviewed his license was suspended or revoked or canceled. There are some inferences that can be made. However, even with those inferences, we don't believe that the state has met their burden related to the driving license suspended the misdemeanor count. Related to the aggravated assault on a law enforcement officer, which the court just heard testimony on, we do not believe that the state has met their burden, that there was an intentional unlawful threat made by Mr. Wright, and then Mr. Wright had the ability to carry out that threat. Our position is there wasn't a threat, so we don't get to number 2 in our analysis. Count 3, there was discussion of whether or not in the mind of the deputy, none Folly was well found to appear that the violence was about to take place. I think the better argument here is this an assault? Is this not an assault? Is this an intentional action? Or is this a continuation of what we did until we would argue today around the grounds related to that count? Grand theft of an automobile. Given that there was testimony that Mr. Wright had borrowed the vehicle lawfully, and that had never been notified that the vehicle was stolen, we would argue that even though it was favorable to the state, there was no evidence that this was a knowingly action. So we would be very heavily upon the word knowingly related to grand theft auto. The court has seen the video of the end of the pursuit related to resisting without violence. Our opinion is that there was no resistance or obstruction if he was giving multiple commands at the same time, and that there was a very short amount of time for that fact out. So we don't believe the state has the burden related to resisting without violence. Both the possession of controlled substance and possession of drug paraphernalia counts would basically be akin to constructive possession. There were no substances or paraphernalia found on Mr. Wright's person. So we would assert lack of knowledge in both the paraphernalia and controlled substance counts and argument JOA.
Yes, ma'am.
Your Honor, every argument that the defense has made is based on the weight and not the sufficiency of the evidence. The test for a JOA is whether or not a rational trier of fact could find the elements proven by the evidence presented. So this is not a test of the weight of the evidence. But to address each one, the driving while license suspended or revoked, the record clearly shows that Mr. Wright obtained an identification card after his license was suspended, and his license has been suspended since approximately 2011. So that the jury could infer that he had knowledge that his license was suspended.
And that came into evidence when?
That came into evidence through the certified driving record, Your Honor.
Thank you.
Everything else is just opinion on the evidence, Your Honor, that the defense has made an argument regarding. The fleeing to elude. Mr. Wright was operating a vehicle on the streets or roadways. He had been directed to stop in a vehicle with lights and sirens. The vehicles had prominent displays, as shown in the video, of Sheriff's Office insignia and he was driving up and down the roadways, going the wrong way with a wanton disregard for the safety of persons and property. When it comes to the aggravated assault on a law enforcement officer, whether or not he was driving toward Sergeant Folly at the time is an issue for the jury. Again, that goes to weight and not the sufficiency of the evidence. The jury should be allowed to determine whether or not Mr. Wright was heading towards Deputy Folly, and he testified that he believed he was heading towards him and that he did have to swerve to avoid being hit. As to the grand theft of an automobile, Ms. Barabecchio testified that she told him multiple times to bring the car back and that he did not. She testified that she was going to report it to the police if he did not bring it back. He did not bring the car back. She did report it to the police. That is for the jury to decide whether or not the car was stolen. As for resisting law enforcement officers without violence, again, that's on video. Whether or not Mr. Wright resisted or obstructed the officers is an issue for the jury to determine. Possession of a controlled substance, Mr. Wright was the sole occupant of the vehicle. The items were hanging from the steering wheel, and whether or not Mr. Wright possessed those substances is within the purview of the jury. The same with the paraphernalia, Your Honor, that was found. So again, the state argues that the defense has argued as to the weight and not the sufficiency of the evidence. The state has presented competent, substantial evidence for all of the counts as charged, and the jury should be allowed to decide each count.
Mr. McKinney, it's your motion to get the last word.
Judge, specifically related to, he got an identification card after the fact. It doesn't show anything that he knew his license was suspended at the time of the action. And if we look at the driving record that's been provided in evidence, it shows that there was a notice sent. We don't know where that notice was sent, but it was sent in 2012. This was an occurrence in 2021. So we would argue that there's been no evidence that can be interpreted at all by the court, even in light of articles of the state on that he had notice and knew that his license was suspended at the time. Thank you.
What exhibit number is the driving record?
I believe it's number 4.
Sandler, Mr. McKinney stated some presumptions. You didn't expound on that as far as Mr. Wright knowing that he didn't have a valid driver's license.
And, Your Honor, in the jury instructions for driving while license suspended or revoked, it states proof that there exists an entry in the records of the Department of Highway Safety and Motor Vehicles showing that notice of the suspension, revocation, or cancellation was deposited in U.S. mail, first class postage prepaid addressed to the licensee at his last known mailing address furnished to the department is proof that such notice was sent.
Okay, so where is there evidence of that notice being sent?
It would be in the record to the side. It would say date notice is sent, if I may look.
Yes, ma'am, please.
So, Your Honor, on page 2 of the record, it will state the length of the suspension, the county of the suspension, the effective date, and to the right of all of that, with an asterisk, it says notice provided date. And that's the date that the notice was provided to Mr. Wright. And if it was deposited in the mail, which it always is, then, and it will say, notices are mailed to the last address provided to our agency pursuant to statute 322.251. In those cases, the notice is mailed 20 days before the sanction begins. So that's the notice provided date, Your Honor. So the notices were provided to him on all of these dates that his license was suspended. And then in the record, it says the issue date, the last issue date for his driver's license, and then he has an identification card issue date as well. So if he gets an identification card, and this is the state's argument, if he goes in and goes to the Department of Highway Safety and Motor Vehicles and gets an identification card instead of a driver's license, he knows his license is suspended. May I turn that?
Yes, ma'am, thank you. Mr. McKinney, based on the court's questions, do you have anything to add? Yes, sir.
Judge, reading that, the jury instructions are effectively controlling here, simply because there was entry in the record that proof was sent somewhere, doesn't mean that the proof was necessarily sent to Mr. Wright. So that would be the argument from the defense, specifically related to what's been provided to Wright.
Thank you, sir. Mr. Wright, it's not just a rubber stamp from the court. The court can just say denied and go on. You've got to follow the law, wherever that leads me. I look at the Florida Supreme Court case. It's one back in 2013. It was Blackman versus State. And in there, the Florida Supreme Court said, where the state has presented competent, substantial evidence of the crimes charged. So I look at that. I look at the elements of those crimes. Easy to do in this environment because we have proposed jury instructions that set forth those elements. But the Florida Supreme Court says if those things are present, the trial court does not err in denying a motion for judgment of acquittal and submitting the case to the jury. So I do find that the state has presented that competent evidence. It will be questions of fact for the jury to determine. So respectfully, the motion for judgment of acquittal on each count is denied. What else, Mr. McKinney? What else do we need to do?
Judge, I think it would be appropriate at this time to ask both you and the attorney-client to speak with my client to make sure where we're at in the proceedings, if we need to address the court, that we know what we're talking about.
Okay. So you're going to discuss with Mr. Wright about his right to testify and not testify. Then anything else that the court can be preparing for while we're taking a recess?
And then from that position, I think it would be appropriate to address the court related to pros and cons of testifying, if you like, decision. I believe the appropriate conversation would be the written confession of guilt made by the defense in closing to the jury. That would be an appropriate conversation, and prosecuting conversation to have with Mr. Wright prior to us standing up in closing. But because of the law questions, Mr. Wright, that's why I want to talk to him back before we come back.
Okay, good. Just so I can get rid of the little post-it that I put on the bench a while back. Both of you would tell any witnesses that you call. The court intentionally doesn't look at a witness when they come up and make eye contact or nod or anything, because I don't want the jury to see that and think that I'm giving some credibility to that witness. So I intentionally avert my eyes from them, and I don't want anybody to feel alienated because the court does that. I'm doing it intentionally. So I wanted you to know that. How long will you need, Mr. McKinney?
10 minutes.
Okay. We're in recess for 10 minutes.
All rise. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Wright Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m. serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Wright Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Yeah, it's locked all around.
Yes, sir. Make a good record with Mr. Wright.
Yes, sir.
It's the defense position, in speaking to Mr. Wright, that he's choosing not to testify, but that's going to prompt questions from the court.
Yes, sir. So, Mr. Wright, have you had sufficient time to speak with Mr. McKinney about your right to testify and not to testify?
Yes, sir.
If you decide to testify, here's what I would read to the jury. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the other witnesses. You understand that possible instruction?
Yes, sir.
If you decide not to testify, here's what I'll read to the jury. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in this case. Do you understand that possible instruction? Yes, sir. Do you still wish to not testify? Yes, sir. Thank you, sir.
Additionally, Judge, if we could raise at this time that there may very well be concessions of guilt on some of the things, given that Mr. Wright is charged with 7 different counts in different charges. Potential defense strategies could include admitting to some things and not others. So that is a discussion that's been had with Mr. Wright that the court may inquire upon.
First, let me ask you, Mr. McKinney, have you discussed those concessions with Mr. Wright?
I have, at length.
Okay. Because you're very vague in what you just stated.
Yes, sir.
How do I make sure that Mr. Wright knows what concessions you're going to do if you don't specifically identify them? And I say that hesitantly because I don't know if you want the state to hear that, but I don't think there's a way. I don't know of a way that you can preserve it without the state knowing it.
And then that does open the door in the defense strategy a little bit, which is why there's a regular language. But I don't believe in this type of a case, given that there are elements that can be proven by video, and specifically related to the thing attempting to elude fact pattern, that we can realistically argue on other counts without conceding guilt for things attempting to elude. That to me is basic level.
Without conceding to. Okay. Kind of the other way around is, well, that seemed backwards. So explain that to me again.
It's a defense strategy to concede facts related to the claim attempting to elude.
Okay. Yes, sir.
If there is going to be argument against things that are within that same fact pattern,
yes,
which would be the aggravated assault on law enforcement, if that's part of the same fact pattern.
I understand. Which is consistent with what your questioning has been.
Correct.
Mr. Wright, have you had sufficient time to speak with Mr. McKinney about him providing concessions, basically admitting that you may have committed certain crimes in order for Mr. McKinney to raise other defenses of other crimes? Do you have any questions for Mr. McKinney or the court based on that? Okay. You consent to those concessions?
Yes.
It's a trial strategy, but as I started in the very beginning, before we even brought in the venire, I said, before you make any concessions, let's get it on the record. You need to be on the same page with your attorney. So I appreciate it.
Yes.
Thank you, sir.
Thank you.
Yes, sir.
Judge, for the record, the defense would be resting, and we can announce that formally or informally in front of the jury.
Yes, sir.
We would be renewing our motions for judgment of acquittal on the same basis. So then the court will need to rule on the renewed JOA, and then we will need to determine whether or not we want to bring the jury back in to formally arrest and then send them back out to prepare for closing, or if we want to take this time to prepare for closing and then come back out.
I would suggest that with you resting, you're making that motion for judgment of acquittal again. The court respectfully denies that motion. There hadn't been any other evidence, so it's not a difficult decision for the court. So then at this point, I'd say, let's get together the final jury instructions. We'll make those changes, bring in the jury one time. I'll give them the final instructions, then you make the closings, and then I'll give them the final instructions.
Yes, sir.
Your Honor, would it be appropriate to tell the jury that we're working a little bit longer?
I think that would be a great idea. If you, wait a minute, hold on one second. What exactly are we going to tell them? Are we going to tell them that we're working on the final jury instructions? What do you want to tell them?
I would use the standard language we're just going to work out so that these can be done outside the presence of the jury as quickly as we can.
And it's work that we couldn't have done previously? Or at this stage in the trial, we're doing some additional work outside of your hearing?
Yes, it's required to be outside of your hearing. It did not be done previously.
Okay. Yes, sir. Thank you. He's telling me that. Thanks, Allison. We hear things different ways. Okay, on the proposed jury instructions. First off, I didn't see another verdict form that maybe we didn't have to have.
The court working off of what was emailed to us last.
I emailed a new set of jury instructions. I did not email the verdict form because nothing had changed. The verdict form is the same as was emailed yesterday.
Okay. So, count 7. Which is the new page 15, I believe. Yes. Page 15, the bottom of that. Which of those, if any, do you want the jury to hear?
Your Honor, I would propose taking out anything except the sentence that begins with scales and balances used, intended for use, or designed for use. Capsules, balloons, envelopes, or other containers used. Containers and other objects.
Okay, wait a minute, hold on. So it's number 2, number 4,
Yes.
and what other number? Number 5.
I believe that's number 5, containers and other objects.
Okay, so capsules is going to come out.
Capsules, balloons, and other containers intended for use instead. Packaging small.
So number 2, number 4, number 5. Any other ones you believe should stay?
I've already made edits to their balance. And if you have records, so you can balance it. I will read in number 2, number 4, number 5, and number 7.
All of number 7?
All of number 7. Although I'm okay taking out some of it if it's done some preferred.
I'm looking at 7 to determine what testimony you actually have based on what's listed under A through G.
It's the position of the state this isn't necessarily an exhaustive list of what could be considered paraphernalia, but there is testimony in the introduction of the cut straw, which would be part of number 7, ingesting, inhaling, or otherwise introducing.
which would be under 7A.
I will be okay reading A and taking out the G.
Read your G. That would be the request of the defendants would be to remove 7A, all of A, and remove B through G.
Okay. Are we just going to have an A and no letter under that?
I was about to say the grammar nerd in me wants to change it to colon, metal wooden acrylic, and instead of having it take metal.
The defendants would be fine with that.
And just for continuity purposes, this is page 16.
Yes, ma'am. Then, do you want to keep in 1 through 7 on page 19 or removing it?
I think it'd be appropriate to remove 6 and 7.
Any objection from the state?
No objection, Your Honor.
Then remove page 21.
And that would be defendant testifying.
Correct.
The statement under that.
So, Mr. McKinney, the prior proposed verdict form was acceptable?
Yes, yes.
I don't see any other changes in the verdict form of the proposed jury instructions. Mr. McKinney, any other concerns on those?
No, no.
So there'll be 7 for the jury, 8, Madam Clerk, 9 for the court, 10 for the court order, 11 for the defense, and then whatever the state wants. Only one verdict form for me to send back to the jury. And I've got that, so I'm good on the verdict form. I'll get that to Madam Clerk where she sends it back.
Just to be sure, Your Honor, I have 26 pages of jury instructions.
Yes, ma'am, because, well, I've got 28 pages, the last page only has 2 lines, and you removed the defendant testifying, so we're 1 page different.
And I believe I removed the defendant's statements because none of them were wrong.
Okay.
That's okay with that?
That was in page 23, I believe, and no problem with that.
Good, thank you.
Did the court want me to change the font to submitting a case to jury and make it 1 less page?
No, ma'am.
Okay. I just want to make sure.
You're doing enough work to help the court, whatever's easiest for you.
And I would ask that approach with the state and review the verdict form before Your Honor passes it over to Madam Clerk, just to make sure that it is what we discussed.
Please, if you'll approve.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict.
So it's exhibit 8. Anything else we need to do before the state prints the final instructions?
Nothing from the state, Your Honor.
There you go.
Thank you. How long do you think we should take, Ms. Sandler?
15 minutes?
Okay.
I think if that's okay.
Yes, ma'am, that's fine. Is that enough time for you? Want to make it 20?
15 should be fine.
Okay. We're in recess for 15 minutes.
All right.
Thank you.
You're taking your case to trial. Be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Wright Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Wright Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at daystirepros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Wright Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
so much. If you want to put those on your seats or in front of you. Great, thank you. No. Thank you. I'm glad you reminded me again. Are we ready for the jury?
State's ready.
Can you stand for the jury? Mr. McKinney, I will ask you to call your first witness, or just yes. Thank you. Please be seated. Mr. McKinney.
Judge, at this time, the defense rests.
Thank you, sir. So, ladies and gentlemen of the jury, you'll notice that you've got the final jury instructions. I will read through these with you. You can take these back with you when you deliberate. If you make any notes on those, and I see any notes, I'll shred them just like any other notes that you have. So you'll be able to take these back with you. Again, make any notes on them if you wish. So I'll give you the vast majority of these instructions other than the last 2 pages, and then the attorneys will give you their closing arguments, and then I'll read to the last 2 pages. So don't read ahead of those last 2 pages. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Wendall Joseph Wright, the defendant in this case, has been accused of the crimes of count 1, fleeing to elude a law enforcement officer, siren and lights activated with high speed or reckless driving. Count 2, driving while license canceled, suspended, or revoked. Count 3, aggravated assault on a law enforcement officer. Count 4, grand theft of an automobile. Count 5, resisting a law enforcement officer without violence. Count 6, possession of a controlled substance. Count 7, possession of paraphernalia. In considering the evidence, you should consider the possibility that, although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser crimes indicated in the definition of fleeing or attempting to elude a law enforcement, it should say officer. If you don't mind writing that in. So the line reads, the lesser crimes indicated in the definition of fleeing or attempting to elude a law enforcement officer. This is on page 3. In the left-hand margin, it has enforcement with a capital E. Just behind that, it needs to say officer. So So the lesser crimes indicated in the definition of fleeing or attempting to elude a law enforcement officer in an agency vehicle, siren and lights activated at high speed or reckless driving are 1. Fleeing or attempting to elude a law enforcement officer, siren and lights activated, and 2. Fleeing or attempting to elude a law enforcement officer. The lesser crimes indicated in the definition of aggravated assault on a law enforcement officer are 1. Assault on a law enforcement officer, and 2. Assault. To prove the crime of fleeing to elude a law enforcement officer, siren and lights activated with high speed or reckless driving, the state must prove the following 4 elements beyond a reasonable doubt. 1. Wendall Joseph Wright was operating a vehicle upon a street or highway in Florida. 2. Wendall Joseph Wright, knowing he had been directed to stop by a duly authorized law enforcement officer, willfully fled in a vehicle in an attempt to elude a law enforcement officer. 3. The law enforcement officer was in an authorized law enforcement patrol vehicle with agency insignia and other jurisdictional markings prominently displayed on the vehicle and with siren and lights activated. 4. During the course of the fleeing or the attempt to elude, Wendall Joseph Wright drove at high speed or in any manner demonstrating a wanton disregard for the safety of persons or property. Street or highway means the entire width between boundary lines of every way or place of whatever nature when any part thereof is open to the public for purposes of vehicular traffic. Vehicle means every device in, upon, or by which any person or property is or may be transported or drawn upon a highway. Willfully means intentionally, knowingly, and purposely. To prove the crime of fleeing to elude a law enforcement officer, siren and lights activated, the state must prove the following 3 elements beyond a reasonable doubt. 1. Wendall Joseph Wright was operating a motor vehicle upon a street or highway in Florida. 2. Wendall Joseph Wright, knowing he had been directed to stop by a duly authorized law enforcement officer, willfully fled in a vehicle in an attempt to elude a law enforcement officer. 3. A law enforcement officer was in an authorized law enforcement patrol vehicle with agency insignia and other jurisdictional markings prominently displayed on the vehicle and with siren and lights activated. Street or highway means the entire width between boundary lines of every way or place of whatever nature when any part thereof is open to the public for purposes of vehicular traffic. Vehicle means every device in, upon, or by which any person or property is or may be transported or drawn upon a highway. Willfully means intentionally, knowingly, and purposely. To prove the crime of fleeing to elude a law enforcement officer, the state must prove the following 3 elements beyond a reasonable doubt. 1. Wendall Joseph Wright was operating a motor vehicle upon a street or highway in Florida. 2. A duly authorized law enforcement officer ordered the defendant to stop or remain stopped. 3. Wendall Joseph Wright, knowing he had been ordered to stop by a duly authorized law enforcement officer, willfully refused or failed to stop the vehicle in compliance with the order. Street or highway means the entire width between boundary lines of every way or place of whatever nature when any part thereof is open to the public for purposes of vehicular traffic. Vehicle means every device in, upon, or by which any person or property is or may be transported or drawn upon a highway. Willfully means intentionally, knowingly, and purposely. To prove the crime of driving while license was suspended, revoked, or canceled, the state must prove the following three elements beyond a reasonable doubt. 1. Wendall Joseph Wright drove a motor vehicle upon a highway in this state. 2. At that time, his license was suspended, revoked, or canceled. 3. At that time, Wendall Joseph Wright knew that his license was suspended, revoked, or canceled. Whether Wendall Joseph Wright knew of the suspension, revocation, or cancellation is a question to be determined by you from the evidence. Proof that there exists an entry in the records of the Department of Highway Safety and Motor Vehicles showing that notice of the suspension, revocation, or cancellation was given by personal delivery is proof that such notice was given. Proof that there exists an entry in the records of the Department of Highway Safety and Motor Vehicles showing that notice of the suspension, revocation, or cancellation was deposited in the United States mail, first class, postage prepaid, addressed to the licensee at his last known mailing address, furnished to the department, is proof that such notice was sent. If you find that Wendall Joseph Wright admitted to knowing of the suspension, revocation, or cancellation, you may conclude that Wendall Joseph Wright knew of this suspension, revocation, or cancellation. If you find that Wendall Joseph Wright had received a traffic citation that contained a provision notifying Wendall Joseph Wright that his license had been suspended, revoked, or canceled, you may conclude that Wendall Joseph Wright knew of the suspension, revocation, or cancellation. Drive means to operate or be in actual physical control of a motor vehicle in any place open to the general public for purposes of vehicular traffic. Motor vehicle means any self-propelled vehicle, including a motor vehicle combination not operated upon rails or guideway, excluding vehicles moved solely by human power, motorized wheelchairs, and electric bicycles. Highway means the entire width between the boundary line of every way or place, if any part thereof is open to the use of the public for purpose of vehicular traffic. Notice means personal delivery or deposit in the United States mail, first class, postage prepaid, addressed to the defendant at his last known address, furnished to the Department of Highway Safety and Motor Vehicles. Mailing by the department shall constitute notification. Suspended means the privilege to drive a motor vehicle has been temporarily withdrawn. Revoked means the privilege to drive a motor vehicle has been terminated. Canceled means that a license has been declared void and terminated. Actual physical control of a motor vehicle means the defendant must be physically in or on the motor vehicle and have the capability to operate the motor vehicle regardless of whether he is actually operating the motor vehicle at the time. To prove the crime of aggravated assault on a law enforcement officer, the state must prove the following 7 elements beyond a reasonable doubt. The first 3 elements define assault. 1. Wendall Joseph Wright intentionally and unlawfully threatened, either by word or act, to do violence to Deputy Donald J. Folly. 2. At the time, Wendell Joseph Wright appeared to have the ability to carry out the threat. 3. The act of Wendell Joseph Wright created in the mind of Deputy Donald J. Folly a well-founded fear that the violence was about to take place. 4. The assault was made with a deadly weapon. 5. Deputy Donald J. Folly was at the time a law enforcement officer. 6. Wendell Joseph Wright knew Deputy Donald J. Folly was a law enforcement officer. 7. At the time of the assault, Deputy Donald J. Folly was engaged in the lawful performance of his duties. The court now instructs you that a deputy sheriff is a law enforcement officer. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Deputy Donald J. Folly may be found to have been in fear, and actual fear on the part of Deputy Donald J. Folly need not be shown. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruising. It is not necessary for the state to prove that the defendant had an intent to kill. To prove the crime of assault on a law enforcement officer, the state must prove the following 6 elements beyond a reasonable doubt. 1. Wendell Joseph Wright intentionally and unlawfully threatened, either by word or act, to do violence to Deputy Donald J. Folly. 2. At the time, Wendell Joseph Wright appeared to have the ability to carry out the threat. 3. The act of Wendell Joseph Wright created in the mind of Deputy Donald J. Folly a well-founded fear that the violence was about to take place. 4. Deputy Donald J. Folly was, at the time, a law enforcement officer. 5. Wendell Joseph Wright knew Deputy Donald J. Folly was a law enforcement officer. 6. At the time of the assault, Deputy Donald J. Folly was engaged in the lawful performance of his duties. The court now instructs you that a deputy sheriff is a law enforcement officer. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Deputy Donald J. Folly may be found to have been in fear, and actual fear on the part of Deputy Donald J. Folly need not be shown. To prove the crime of assault, the state must prove the following 3 elements beyond a reasonable doubt. 1. Wendell Joseph Wright intentionally and unlawfully threatened, either by word or act, to do violence to Deputy J. Folly. 2. At the time, Wendell Joseph Wright appeared to have the ability to carry out the threat. 3. The act of Wendell Joseph Wright created in the mind of Deputy Donald J. Folly a well-founded fear that the violence was about to take place. To prove the crime of grand theft of an automobile, the state must prove the following 2 elements beyond a reasonable doubt. 1. Wendell Joseph Wright knowingly and unlawfully obtained or used the motor vehicle of Jessica Veravecchio. Number 2. He did so with the intent to either temporarily or permanently A. deprive Jessica Veravecchio of her right to the property or any benefit from it. B. Appropriate the property of Jessica Veravecchio to his own use or to the use of any person not entitled to it. Motor vehicle means an automobile, motorcycle, truck, trailer, semi-trailer, truck, trailer, truck, tractor, and semi-trailer combination, or any other vehicle operated on the roads of this state, used to transport persons or property, and propelled by power other than muscular power, but the term does not include traction engines, road rollers, motorized scooters, micro-mobility devices, personal delivery devices, mobile carriers, special mobile equipment, vehicles that run only upon a track, bicycles, electric bicycles, swamp buggies, or mopeds. To prove the crime of resisting a law enforcement officer without violence, the state must prove the following 4 elements beyond a reasonable doubt. To prove the crime of resisting a law enforcement officer without violence, the state must prove all of the following 4 elements beyond a reasonable doubt as to at least one of the alleged victims named below. 1. Wendall Wright resisted, obstructed, or opposed Deputy Donald J. Folly and or Deputy David Nash. 2. At the time, Deputy Donald J. Folly and or Deputy David Nash was engaged in the lawful execution of a legal duty. 3. At the time, Deputy Donald J. Folly and or Deputy David Nash was an officer. 4. At the time, Wendall Wright knew Deputy J. Foley and or Deputy David Nash were officers. The court now instructs you that every deputy sheriff is an officer within the meaning of the law. Certain drugs and chemical substances are by law known as controlled substances. Methamphetamine is a controlled substance. To prove the crime of possession of a controlled substance, the state must prove the following 2 elements beyond a reasonable doubt. 1. Wendall Joseph Wright possessed a substance. 2. The substance was methamphetamine. To prove Wendall Joseph Wright possessed a substance, the state must prove beyond a reasonable doubt that he A. knew of the existence of the substance, and B. intentionally exercised control over that substance. Control can be exercised over a substance whether the substance is carried on a person, near a person, or in a completely separate location. Where proximity to a substance does not establish, mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that Wendall Joseph Wright had direct personal power to control the substance or the present ability to direct its control by another. Possession of a substance may be sole or joint, that is, 2 or more persons may possess a substance, whether growing or not, and the seeds thereof. Lack of knowledge of the illicit nature of a controlled substance is a defense to possession of a controlled substance. You may, but are not required to, infer that Wendall Joseph Wright was aware of the illicit nature of the controlled substance if you find that he possessed the controlled substance. If you are convinced beyond a reasonable doubt that Wendall Joseph Wright knew of the illicit nature of the controlled substance and all of the elements of the charge have been proved, you should find him guilty of possession of a controlled substance. If you have a reasonable doubt on the question of whether Wendall Joseph Wright knew of the illicit nature of the controlled substance, you should find him not guilty of possession of a controlled substance. To prove the crime of use or possession with intent to use drug paraphernalia, the state must prove the following two elements beyond a reasonable doubt. 1. William Joseph Wright knew of the presence of drug paraphernalia. 2. Wendall Joseph Wright possessed the drug paraphernalia with intent to use it, A, process, prepare, test, analyze, pack, repack, store, contain, or conceal a controlled substance, or B, inject, ingest, inhale, or introduce a controlled substance into the human body. The court instructs you that methamphetamine is a controlled substance. To prove Wendall Joseph Wright possessed drug paraphernalia, the state must prove beyond a reasonable doubt that he, A, knew of the existence of the drug paraphernalia, and B, intentionally exercised control over that drug paraphernalia. Control can be exercised over drug paraphernalia whether the drug paraphernalia is carried on a person, near a person, or in a completely separate location. Mere proximity to drug paraphernalia does not establish that the person intentionally exercised control over the drug paraphernalia in the absence of additional evidence. Control can be established by proof that Wendall Joseph Wright had direct personal power to control the drug paraphernalia, or the present ability to direct its control by another. The term drug paraphernalia means all equipment, products, and materials of any kind which are used, intended for use, or designed for use in planting, propagating, cultivating, growing, harvesting, manufacturing, compounding, converting, producing, processing, preparing, testing, analyzing, packaging, repackaging, storing, containing, concealing, transporting, injecting, ingesting, inhaling, or otherwise introducing into the human body a controlled substance or a substance listed in Section 877.111 Florida statutes. The court instructs you that methamphetamine is a substance listed in Section 877.111 Florida statutes. It includes, but is not limited to, 1. And if you will, if you'll strike that instruction, gives specific definition as applicable, because these are applicable. So it's, but not limited to, number 1, scales and balances used, intended for use, or designated for use in weighing or measuring controlled substances. 2, capsules, balloons, envelopes, and other containers used, intended for use, or designed for use in packaging small quantities of controlled substances. 3, containers and other objects used, intended for use, or designed for use in storing or concealing controlled substances. 4, objects used, intended for use, or designed for use in ingesting, inhaling, or otherwise introducing controlled substances or a substance listed in Section 877.111 Florida statutes into the human body, such as metal, wooden, acrylic, glass, stone, plastic, or ceramic pipes with or without screens, permanent screens, hashing heads, or punctured metal bowls. In addition to all other logically relevant factors, the following factors shall be considered in determining whether an object is drug paraphernalia. 1, the proximity of the object in time and space to a direct violation of the drug laws. 2, the proximity of the object to controlled substances. 3, the existence of any residue of controlled substances on the object. 4, the existence and scope of legitimate uses for the object in the community. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial until it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. You have heard testimony of eyewitnesses. You have heard testimony of eyewitness identification. In deciding how much weight to give to this testimony, you may consider the various factors mentioned in these instructions concerning credibility of witnesses. In addition to those factors, in evaluating eyewitness identification testimony, you may also consider 1, the capacity and opportunity of the eyewitness to observe the offender based upon the length of time for observation and the conditions at the time of the observation, including lighting and distance. 2, whether the identification was the product of the eyewitness's own recollection or was the result of influence or suggestiveness. 3, the circumstances under which the defendant was presented to the eyewitness for identification. 4, any inconsistent identifications made by the eyewitness. 5, any instance in which the eyewitness did not make an identification when given the opportunity to do so. 6, the witness's familiarity with the subject identified. 7, lapses of time between the event and the identification. 8, whether the eyewitness and the officer are of different races or ethnic groups, and whether this may have affected the accuracy of the identification. 9, the totality of circumstances surrounding the eyewitness's identification. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in this case? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. It is entirely proper for a lawyer to talk to a witness about what testimony the witness will give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict rendered as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. These are some general rules that you must follow, general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits in evidence and these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. And you'll see that word more than once in these instructions. So whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, the jury is not to discuss any questions that a juror wrote. Well, that really didn't apply, so I'll go to the next number, 8. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the information or not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, a necessary verdict form has been prepared for you. It is as follows. And you don't have that verdict form yet, I will send out one verdict form when you go back to deliberate. And after I take a swig of water, I'll read the verdict form to you. So the verdict form reads as follows. In the Circuit Court for Okaloosa County, Florida, State of Florida Plaintiff versus Wendall Joseph Wright, Defendant. Clerk number 4621 CF 001776A, Division 002. Verdict. We, the jury, find as follows as to the counts charged in the information. Count 1, and it instructs, choose 1. And in the left-hand margin, there's a blank line. Guilty of fleeing to elude a law enforcement officer. Siren and lights activated at high speed or reckless driving. Under that, another line. Guilty of fleeing to elude a law enforcement officer. Siren and lights activated. A lesser included offense. Under that, another line. Guilty of fleeing to elude a law enforcement officer, a lesser included offense. Under that, another line, not guilty. Count 2. There's a line in the left-hand margin. Guilty of driving while license canceled, suspended, or revoked. Under that, another line, not guilty. Count 3, and it instructs, choose 1. In the left-hand margin, a blank line. Guilty of aggravated assault on a law enforcement officer. Under that, another blank line. Guilty of assault on a law enforcement officer, a lesser included offense. Under that, another blank line. Guilty of assault, a lesser included offense. Under that, another blank line, not guilty. Count 4. Blank line, guilty of grand theft of an automobile. Another blank line, not guilty. Count 5, a blank line, guilty of resisting a law enforcement officer without violence. Under that, another blank line, not guilty. Count 6, a blank line, guilty of possession of controlled substance. Under that, blank line, not guilty. Count 7, blank line, guilty of possession of paraphernalia. Under that, another blank line, not guilty. So say we all this blank day of blank, 2023, there's a place for the foreperson to sign their name and then print their name. Ms. Sandler, would you like to make a closing argument?
Good afternoon. I know it's late. I know some of us are yawning. But I thank you for your time and attention during this trial and paying attention to the evidence the state has presented. Just to give you a brief overview of the evidence we've presented and the events. Wendall Joseph Wright stole Jessica Barrett-Lee's car. He didn't give it back to her. That's stealing. Pure and simple. The car was identified by law enforcement officers and followed. You heard Deputy David Nash testify that he followed the vehicle, and as the vehicle turned on Sunset and Shalimar onto Edwin Parkway, he turned on his lights and sirens. And then you got to see that on video. Mr. Wright did not stop. Mr. Wright proceeded to flee from law enforcement. And you heard from Deputy Folly that he was making rude gestures, yelling and screaming. Most importantly, and we're talking about the elements of the offenses, I want you to keep in mind that Mr. Wright went across the median. He went northbound and a southbound lane, and southbound and a northbound lane, putting countless amounts of cars and people in danger. And during the course of this, you heard Deputy DJ Folly tell you that he stopped thinking Mr. Wright was about to flee. He was going to get out of his car, and then he saw Mr. Wright come straight towards him, and he had to take an evasive action because he believed he was going to be hit purposefully by Mr. Wright. And then Deputy Folly made the decision he was going to use a maneuver to hit Mr. Wright because of the danger he was presenting to the community. And then afterwards, Deputy Lapide performed an inventory search, and he found methamphetamine and paraphernalia in the car. It's a pretty simple case. There's 7 charges. There are a lot of evidence, and we'll go through them. Claiming to elude a law enforcement officer, lights and siren and lights activated with high speed for reckless driving. Nobody saw that it was definitely a law enforcement officer on the video. He was definitely operating a vehicle upon a street or highway, and he had been directed to stop by a law enforcement officer. He willfully fled. We saw that those were all agency marked vehicles. There was no mistaking that those were law enforcement officers trying to stop Mr. Wright. And during the course of the fleeing or attempting to elude, he drove at a high speed. And I don't know if you can see this very well, but this is a still shot from Deputy Nash's camera. And that's approaching 80 miles an hour. Or in a manner showing a wanton disregard for the safety of persons or property. That's Mr. Wright going southbound. Going northbound in a southbound lane with all those cars there. So the state is asking you to find Mr. Wright guilty on count 1, fleeing to elude a law enforcement officer, siren and lights activated with high speed for reckless driving. Driving while license suspended, revoked, or canceled. This isn't one we talked about a whole lot or presented a lot of evidence on. I can speak to it. But you heard Deputy Nash say he later determined that his license was suspended. Now the trick to that is learning how to read Exhibit 4. And it shows that Mr. Wright had a suspended license. It shows that Mr. Wright was notified of his suspended license and the dates that the notice was provided. If you look at page 2, it says notice provided, and it has a nice little asterisk right there just to tell you what days the notice was provided. Gives you a description of the reasons why the license was suspended and how long it was suspended for, what years those were effective. Now, how do we know that he knew his license was suspended? Well, if you look up here, you can see that it says he has a Class C license. It's suspended, when it was issued, and when it expired. And then you can see after that he got an identification card. He didn't go in and get a new license. He got an ID card. The issue date and the expiration date for that. He knew his license was suspended. That's why he went and got an ID card. So on count 2, you can see from the video, he's driving a motor vehicle on the highway. He knew his license was suspended, revoked, or canceled. And at that time, he knew his license was suspended, revoked, or canceled. And I put that up for you. His license has been indefinitely suspended since 2000. This is the one that the state anticipates defense will spend most of their time on, trying to explain to you why this wasn't what happened. Aggravated assault on a law enforcement officer. It's quick on the video. And you have to find 7 elements. That Wendall Joseph Wright intentionally and unlawfully threatened either by word or act to do violence to Donald J. Folly. And the act is important here, because there's a car coming straight at him. That's the act. He doesn't have to say anything, he just has to do something, and he did. He appeared to have the ability to carry out that threat. Well, that car was coming right towards Deputy Folly. That was the ability. The act created in the mind of Deputy Donald J. Folly a well-founded fear that the violence was about to take place. You heard him testify. He was scared that he was going to get hit, so he took action. That's what he's trained to do. The assault was made with a deadly weapon. And I know when we talk about deadly weapons, most people think about guns and knives and things like that. You don't think about a car. A car is a deadly weapon. But a car, as the instructions tell you, an object not designed to inflict bodily harm may be a deadly weapon if it's used or threatened to be used in a manner likely to cause death or great bodily harm. Well, a car coming right towards you to hit you can cause death or great bodily harm. Absolutely, a car becomes a deadly weapon. We know Deputy Folly was a law enforcement officer at the time. We know Wendall Wright knew he was a law enforcement officer at the time because he was in the car, driving the car with the lights and sirens going and making these rude gestures at him. And at the time of the assault, he was engaged in the lawful performance of his duties. He testified he was. He was helping other officers in the pursuit. He was actually the supervisor on duty at the time. He took it over. So we ask you to find Wendall Joseph Wright guilty on count 3, aggravated assault on a law enforcement officer. In that photo, you can see the collision. That was the act. Please keep that in mind as you deliberate. Count 4, grand theft of an automobile. All we have to do is prove that he knowingly and unlawfully obtained or used the motor vehicle. And he did so to either temporarily or permanently deprive Jessica Baravecchio of her right to it. She let him borrow it. She said, bring it back. Bring it back, bring it back, bring it back. She testified she gave him multiple opportunities to bring it back before she reported it stolen. She is not required, and it is not in these jury instructions, that she has to call him and tell him, I am reporting the car stolen on this date if you don't bring it back to me. She's already asked for it back. He didn't bring it back. It is stolen at that point. And then she did call, and she did report it to the Okaloosa County Sheriff's Office. He has my car. He won't bring it back. It's stolen. You also saw in the car all of the items, and his items hanging from the steering wheel. He was keeping and using that car. It doesn't appear from the evidence that he had any intention of bringing it back. The state asks you to find him guilty on count 4, grand theft of an automobile. She identified that car, and she told you he spray painted that car. And I want you to keep that in mind too, about the theft. He changed the car. Resisting arrest without violence. There's 4 elements here. He resisted, obstructed, or opposed Deputy Donald J. Folly or Deputy Nash. They were both telling him to get out of the vehicle. He had a way to get out of the vehicle. It might have been fast-paced. It might have been chaotic. Unlock the door, unlock the door, unlock the door. Try the back door. He's not unlocking the doors. He's not making any attempt to get out of the car, and they're telling him to get out of the vehicle. He's not trying to comply. The deputies were engaged in a lawful execution of their legal duty. They were trying to stop him. They were officers, and Wendall Wright knew they were officers. The state has met their burden and proven all those elements to you, and he is guilty of resisting a law enforcement officer without violence. Possession of a controlled substance. We anticipate that you'll be told, well, we don't know that was his. We're not sure that was his. That was found afterwards. That was found during an inventory search. Could have been anybody's. It was in a pouch hanging from the steering wheel from the car he was driving that Jessica Veravecchio lent to him. It wasn't in the trunk. It wasn't in somebody else's backpack. It was right there on the steering wheel. And Sam Catalani told you this is methamphetamine. Methamphetamine is a controlled substance. The judge instructed you. This pen is mine. If I go to the restroom, this pen is still mine. If Mr. Wright gets pulled out of a vehicle, that methamphetamine is still his. He possessed the substance was methamphetamine, and we ask you to find him guilty of possession of a controlled substance. Count 7, drug paraphernalia. You got a lot of it. He's only charged with 1 count. You got baggies, you got a straw, you got a scale. You got a lot of baggies. Found in the passenger side. That was a lot of baggies, and you'll see them when they come back with you. He had a scale, and he had a cut straw. And you heard that in Deputy Lepe's training and experience, these are used for narcotics. So all you have to find is he knew there was drug paraphernalia. It's in the passenger seat. He knows it's there. And he possessed it with the intent to either process, prepare, test, pack, repack, store, container, conceal, or inject, ingest, inhale a controlled substance. He had plenty of paraphernalia, and we ask you to find him guilty of possession of drug paraphernalia. These are 7 counts, and the state has given you evidence of all 7 counts that Mr. Wright is guilty beyond a reasonable doubt. And we ask you, when you go back there and deliberate, to find Mr. Wright guilty of all 7 counts as charged. Thank you for your time and attention today.
Thank you, Ms. Sandler.
May it please the court, statement. Ladies and gentlemen of the jury, give me just a moment to drive this thing around. We've got 7 charges to talk about. And you have to make a decision on each one of them. And that decision you're going to be making is, has the state proven the case beyond and to the exclusion of every reasonable doubt? You have to decide that in each count. You've had the benefit of watching video of what happened. You've heard from witnesses about what happened. You, as the jury, get to decide what is the best evidence for me to rely upon. You can believe or disbelieve any of the testimony that you've heard, and you can certainly watch the video as many times as you want when you go back and deliberate. Nobody is asking you to check your common sense at the door. We're asking you to go back and watch that video again so you can watch exactly what happened and fit it to the elements and the law that you've been read. When we talk about count 1, fleeing attempting to elude a law enforcement officer with siren lights activated, that's really not why I'm standing here. When we get to the other counts, then we start running into reasonable doubts. Count 2. And let me talk about reasonable doubt for just a second. Reasonable doubts can arise from the evidence that you've heard, conflicts in the evidence, the lack of evidence. And you do have a lot to consider here. You've got video of what happened from different perspectives that you can go back, watch, apply your experience to, and apply the law. That's what we're asking you to do. When we get to count 2, the driving while license suspended, it's up to you, not Ms. Sandler with the State Attorney's Office, to decide whether or not Mr. Wright knew at the time that his license was suspended. The fact that he got an identification after the fact means nothing about whether or not he knew at the time that his license was suspended. You can look at the document yourself and see that his license was suspended and notice was sent somewhere back in 2012 related to financial responsibility. Once again, Mr. Wright does not have to prove that to you. The state does. Hold the state to their verdict. An appropriate answer here would be not guilty. On count 2 related to the driving while license suspended, go look at the document yourself and make a decision because it is your decision to make. The state's right about count 3. That's primarily why we're here. Is the action that you've seen on the video and heard testimony of an aggravated assault on Deputy Donald Folly? For there to be an aggravated assault, there first has to be an assault. There has to be an intentional action that Mr. Wright unlawfully threatened by word or act to do violence against the deputy. So there's no words. So what action is there? And once again, I implore you, go watch the video. You can apply your experience and watch it yourself to determine what is reasonable. And as you do that, keep into consideration that Mr. Wright does not have to prove anything to you. If there is any doubt in your mind that is reasonable, that equates to a not guilty. The state must prove their case beyond a reasonable doubt. Here, the state has to prove that where there was an intentional action and the language that they just used to you was that he drove straight toward him and right toward him. That's not what you see in the video. You see Mr. Wright for darn near 15 minutes trying to get away from the officers, not going toward them. You see him in the median, and you see Deputy Foley cross the median towards Mr. Wright. Not Mr. Wright crossing the median to Deputy Foley. Judge, may I approach the jury?
Yes, sir, that's one of the exhibits that came in.
Judge, this is, may I approach?
Please.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Because I'm not very good at PowerPoint, I like presentations. This is pretty much the same photograph that you saw on the state's floor. May I approach, please?
To the jury, it's basically a demonstrative aid, so it's not anything that's entered into evidence, that one picture, so it won't go back for your deliberations. In the past, I've had demonstrative aids that were words and things, and juries didn't take notes from them, so I just wanted you to know you see it here in the courtroom, but it won't go back.
And this is a still photograph from the video that you will have access to that you can go watch yourself on close. This is 5 minutes and 56 seconds in this video. Stop it and look at it yourself. In this, you see clearly that there is traffic on the road and that Mr. Wright's vehicle is essentially pinched between that traffic and Deputy Foley's vehicle, which has traveled across the median towards Mr. Wright's vehicle. What you see in the video is continuous. There's no stops and starts. As that Mr. Wright is traveling on the median right where he shouldn't be, going the wrong way. And that he keeps going and that he's pinched by the officer and that there's contact. You heard Deputy Foley say that that was slight, that he got jostled around in the seat, but he sustained no injuries. Is that Mr. Wright going around the traffic? Is that Mr. Wright trying to get away from the officers? Is that Mr. Wright, as the state wants you to think, intentionally threatening the officer? It's not up to you to come back and give us an answer on exactly what was happening. The state has to prove that part beyond the exclusion of every reasonable doubt. The reason why I'm framing it that way is that reasonable doubts exist as to whether or not this is an aggravated assault on law enforcement. And it goes right down to the very beginning of it. Is there an assault or not? Is there an intentional action or not? We submit to you that there is not, but we implore you, go watch the video yourself. You certainly have access to it. That brings us to grand theft of an automobile related to Ms. Barravecchio, who told you that she allowed Mr. Wright to drive her vehicle. There were no definite terms set on where to go, how long. And then at some point in time, her vehicle acted up, and she asked for the vehicle to be brought back. So, if there's conversations between Ms. Barravecchio and Mr. Wright, at what point in time has he stolen anything? He has knowingly but lawfully borrowed the vehicle. That's how this starts. This is not Mr. Wright taking something from Ms. Barravecchio from her house or her driveway. At that point in time, we had friends who helped each other. Mr. Wright was never notified that the car was stolen. That was a surprise to him. Once again, we're back to where is the reasonable doubt? To find grand theft of an automobile, you have to find that Mr. Wright knowingly and unlawfully obtained or used a motor vehicle of Miss Baravecchio. He knowingly used it, but he borrowed it. That is not grand theft auto. Once again, use your common sense. You heard Miss Baravecchio on the stand today. You can believe or disbelieve any of what was said. You are the fact finder, and you make that decision based on what the state has presented to you, or whether or not they have excluded all reasonable doubts in proving their case. We submit to you in that instance, they have not. That this should be a not guilty on grand theft auto, because there are doubts that are reasonable about whether or not this is a stolen vehicle or not, at its most basic level. Resisting a law enforcement officer with violence. We're talking about that 30 seconds after the pursuit is over and after there are multiple deputies approaching Mr. Wright's vehicle, holding him at gunpoint and issuing commands. Did he resist or obstruct or oppose? That's the question here. Are there reasonable doubts that exist on whether or not he resisted, obstructed, or opposed? Did he have time to? If he followed one command and not another, would he have been shot? These are questions you don't have to answer, but they are reasonable doubts. Who should he listen to if he's being yelled at from multiple directions? Is he pulled from the vehicle? Absolutely, he's pulled from the vehicle. The state makes it seem like he should have just got out. Watch the video. His car is pinned up against a police cruiser. Nobody's getting out that door until that cruiser is moving. You have to get out the passenger side. You have to crawl over to the passenger side of the car to get out. Could he have unlocked the car quicker? Could he have unlocked the car? Certainly he could have done that. But he's also got officers saying, show me your hands. Any movement there might have come to a different result. Once again, you don't have to come back and tell us what that result could have been, might have been, but we do have to get past all reasonable doubts for you to find him guilty of resisting without violence. We submit to you that there's a reasonable doubt within that 30 seconds of time in the commands that were given. That brings us lastly to possession. Let's talk about controlled substance and paraphernalia at the same time. Possession, in this instance, doesn't mean mere proximity, just being close to something. The state has to prove to you that he has knowledge that those drugs are there. You cannot just infer that Mr. Wright had knowledge because the drugs were not on his person and that they were not in plain view. So we submit to you that the methamphetamine that was found hanging from the steering column should be found not guilty here because the state has not presented evidence that he had knowledge of the substance. The paraphernalia that we've been discussing was primarily found on the passenger side at the stolen. Same argument exists there. But if we circle back around, that's not really our main topic today. Our main topic is, did Mr. Wright assault Deputy Folly? Or was he just trying to get pulled away? He was not trying to go to. He was trying to go away. Count one is fleeing to elude a law enforcement officer. He was trying to get away. Be that a good decision or a bad decision. We know for sure that he was trying to get away. He was certainly not trying to go to the officer. In this instance, Deputy Foley, being the supervisor, and being in control of that setting in some way, made the decision and told you that the time had come to end the pursuit. After it had been terminated, and after Mr. Wright continued to drive, the decision was made that the pursuit needs to be ended. That's when you see Deputy Foley start crossing the median for the first time. And then shortly thereafter, that's when you see Deputy Foley actually end the pursuit. Once again, take my rendition, take her rendition, watch it yourself. That's your decision to make. If you have any reasonable doubts on any of the elements, on any of these things, you have to find Mr. Wright not guilty. So you have to evaluate each of these 7 counts individually and determine whether or not the state has met their burden on each one. A guilty verdict on one doesn't mean a guilty verdict on 2 or 3 or all. You have to look at them individually and make a decision. In making the decision, we implore you, go back and look at the best evidence, watch the video, and when you do, return a lawful, just verdict. Thank you.
Thank you, Mr. McKinney. Sandler?
Thank you. That photo you just got means nothing. It is one tiny moment in time. One little snapshot of a full event in which Mr. Wright endangered our community by driving up and down the road the wrong way, and then decided he wasn't just on the median, he wasn't just trying to get away. You heard Deputy Donald Folly tell you he is SWAT trained. He's been a law enforcement officer for a long time. Just because he was able to take an evasive action, just because he was able to move out of the way, just because he wasn't hurt, does not mean he was not assaulted. Mr. Wright, if you watch that video and you look at the whole time and not just that snapshot in time, you will see Mr. Wright come toward Deputy Donald Folly and hit him and keep going. The deputies made the decision, actually it was Deputy Folly made the decision to terminate this pursuit the first time because of the danger he was presenting. The second time he knew he had to take him out of commission because of the possibility of death or bodily injury to other people because he had just been hit. So he did a maneuver to the best of his ability to try to stop Mr. Wright from being the danger that he was, from recklessly driving and fleeing and eluding. And when he was finally stopped, when you saw in the video, when Deputy Folly had finally pushed him to the side, away from other people, he was ordered out of the vehicle. Unlock the door. This is resisting arrest without violence. Unlock the door. He never unlocked the door. The Deputy Nash even had to go get another tool. He had plenty of time to just unlock the door, and he didn't. He resisted officers to the last possible second that he could. The last second. They had to pull him out of the vehicle. We ask you to find him guilty of resisting arrest without violence. We ask you to find him guilty of aggravated assault on a law enforcement officer. We ask you to find him guilty of possession of controlled substance. This isn't a case of, well, something was just around, I may not know about it. It was hanging from the steering column. You don't get to, as the defense said, you don't get to check your common sense at the door. The paraphernalia was in with that, and it was in the passenger seat. The law is written in a certain way, and it sounds big and it sounds fancy, but you can infer from the facts and circumstances, you can infer from the evidence presented to you that he knew about the controlled substance and that he knew about the paraphernalia. So the state asks you to find him guilty of possession of controlled substance and possession of paraphernalia. He's certainly guilty of fleeing and eluding with lights and sirens activated in a reckless manner. So the state asks you to find Mr. Wright guilty of all 7 counts as charged, because he is, and because that's what the evidence shows you. That's what the state has presented to you. And we ask you to render that just and true verdict. Thank you.
Thank you, Ms. Sandler. I've been pondering exactly how to say this next thing, because I've never had to say it with a camera in the courtroom. So I never call anybody by their first name, but because there's a camera that's rolling, the most difficult thing I have to do at this point in the trial is release the alternate. And because, Courtney, your last name is unique, I'm not going to say it on camera, but Courtney, we thank you for your service as the alternate. We certainly appreciate it. We appreciate your time yesterday and today, and now you're released. They'll provide you with your certificate. Thank you, ma'am. So the last instructions on page 27 of the instructions that I gave you. In just a few moments, you will be taken to the jury room by the table. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict, and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another, and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case. Until you have reached the verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, tweet, or email, text message, or any other means. Do not contact anyone to assist you during your deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violations of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the bailiff. I was trying to see if this one had. They've added to the civil, and I think they've also added to some of the criminal jury instructions where they talk about knowing to communicate where everybody's in the room. One of the instructions, it says, so if one of you goes to the restroom, stop talking about the case, wait for them to come out. So it's a little more artfully than that, but that's the meaning. Many of you may have cell phones, tablets, laptops, or other electronic devices. Rules do not allow you to bring those phones or other electronic devices in the jury room. It says please leave those. I believe that you've got those in the jury room. The bailiff will remove those when you go back to deliberate. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote in that note. If you have any questions, I would have talked to the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can, in writing or orally, here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. This is a little different than what you've got in writing. All exhibits except Exhibit 8, 11, Exhibits 8, 11, and 13 will be sent into the jury room with you when you begin to deliberate. If you wish to view Exhibits 8, 11, or 13, just send a note through the bailiff to the court, and we'll get everyone to come in, and in the jury box you'll be able to view those 3 exhibits when any one of them goes to the seat. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. So if you'll gather together your notes, the jury instructions, and we will send back the exhibits other than those 3 and the verdict form. If you'll please follow the bailiff. Please stand.